लक्ष्मण चौहान भूल गया। Hello.
Yes, Sumedha ma'am, good evening.
Hey, good evening. I just checked. I thought.
Yeah. So we are just waiting for the participants to join.
Hello? Hello? है ना? हाँ बस और मेरा ये प्रेजेंटेशन इधर रख दो शेयर स्क्रीन करने का है ना अच्छा वो करेगी बाद में
AC वाली साथ में नहीं आ रही यार जल्दी है रही आती
सर गुड इवनिंग तो आ जाएगा
Can you hear me? Now, I think you should hear me.
हेलो
Can you hear me?
या
Yes, okay, fine.
Hello everyone, good evening. So we are just about to start in 5 minutes. We might have to wait for 5 more minutes
दो इसको
to let all participants to join, sir.
535.
आवाज क्लियर नहीं है
एक मिनट।
ये म्यूटेड बोल रहा है
कर दिया now can you hear me now?
Yes, sir, we can hear you. We'll just take 2-3 more minutes to
Okay.
start, sir.
Okay.
Yes, sir.
I think Himani, we should start. Hello?
Okay, sir.
Look, we are talking generally.
Yes.
Because people
yeah,
can
just-
join. See,
yeah.
good evening, friends. It's glad to again talk to all of you. Some people were there on Sunday, and I will just take 5-7 minutes and then we'll give it to Rajat. See, there are lot of emails and the messages come to me as well as to Himani. What are the 2 things which I left for March, month of March? I think there are 2 investment opportunity which we should explore in this month of March. One is, both are fixed income oriented, and because in the month of March we invest, and we are eligible for the index section of the whole year. At today's low interest rate or very little return scenario in a fixed income market, money saved or tax saved is a money earned. So I think what our SLTR model speaks about the fixed income investment, there are certain mutual funds which invest only and only into AAA PSUs or above. That's our safety is taken care. They are all liquid on a T+1 basis. You can redeem your money. You can pledge also and take the short-term loan also. There's a liquidity parameters also taken care. And the beauty is they are all tax efficient. Because if you invest into a debt mutual fund and hold your investment for 3 years, then you are supposed to get index value, and the difference of the sale value minus index value is a long-term gain. So practically, if you invest for 3 years and for indexation, if you invest in the month of March, I think we don't pay any tax. Now coming to today, the interest rate is one of the highest in last 4 years. So we can get approximate 7% tax-free return in AAA and government. I think that this phenomena has happened only after 4 years. After 4 years, I can say we are able to find out a product in which we can get 7% above post-tax returns comfortably without any risk and or as per our formula. I think that is one opportunity we should encash. There are a lot of little things. There are so many funds. So we have selected certain funds of 27 maturity, 28 maturity, 29 maturity. See, the icing on the cake is that suppose the interest rate goes down and we remove the money after 3 years, so we might get some 1% extra return because of the mark-to-market gain. So ideally, we should invest into 2028-29 paper. Some long-term money can be invested 2032. And if we are not in the need of 3 or above, then we can go for 26 paper. So all the papers are there. My team in Pune or I am on the Zoom or the phone is always available. So this phenomena, because of the month of March, we have 10 working days. We can get one full indexation, which is approximate 6%. And the tax on 6% is 20%. Your return can be increased by 1% straight away without thinking. So this was the one idea I left for the fixed income market for the month of March. Second idea is again very simple. As we all know, the interest rates are not going on a very higher rate, and we need long-term cash flows. Then there is a product. See, generally, WealthFirst doesn't go for insurance company for any investment program, but insurance company can give you 30-40 years of vicinity, plus the returns are tax-free. So again, in the higher interest rate, there is a fantastic product came from HDFC Stable, which you invest for 5 years to 10 years, and after 7 years to 12 years, you can get guaranteed tax-free return for 30 years of your life. There is no ifs and buts. It is absolutely black and white. And why again March? Because this product has become reasonably popular in HNI category. So Madam Sitaraman, as under the scanner of the government, after 1st April, they are making this product taxable if you invest more than 5 lakhs and above. So these are the two products before March for a fixed income market we should consider. And again, not only March, because the interest rate is also one of the highest in last 4 years. So we are getting 7% tax-free return for throughout our life. I think India, our tax-free returns of last 25 years history, which I have in rolling return is 7.25. It means suppose you are tax-free, you are highest tax bracket investor in India, and you want to triple and above fixed income return, your average return is not more than 725. Here I am getting around 681 to 7% after tax. I think we should grab this opportunity. Again, in short, debt mutual fund for 3 years to 7 years of horizon and cash flow. I think HDFC Sanchay, everybody, every family should have one product of this, and you should go all out for this, which you get 30 years cash flow assured in your life. I think this is amazing. There's a lot of positives for the investor in this product. I think that one-on-one when we can discuss, we can talk about it. There is a premature availability. So you don't pay after 2 premium also, you don't lose money. So many flexibility for these products and assurity from HDFC. I think that these are the two things I think we should take care of the fixed income investment. Then the last, as you know, after our Sunday, there are within 4 days, these 4 days that looks like 1 year of your life, because of a lot of things are happening into equity market globally in India. Again, like layman with this type of feelings these people are feeling. I think all these things, India is an island of prosperity or better among others, but it doesn't mean that we will not be affected temporarily or short term from all this turmoil of the globe. And again, these 9 months will give you the fantastic opportunity to build up your equity portfolio. See, you will get the stocks or the mutual funds cheaper when the environment is bad. When the sentiment is good, you will never get anything cheap. So I think coming 9 months is going to give you a good opportunity for equity market portfolio. And I believe 24 first quarter to second quarter after election, I believe will be one of the biggest bull run of this country, which is just, it is just waiting for a time, right time to like a volcano to erupt. So summarizing, equity, 6 to 9 months you load your money. Debt fund for 3 to 5 years, you go for debt funds, and perpetually you go for the HDFC Sanchay. That is from my side, Himani. I think a lot of questions were for Rajat also for inheritance, and let us give it to Rajat. We can take questions after that, any point of time. Himani? I think Rajat, you can start.
Yeah. So meanwhile, any of you can drop in your queries in a chat box or can raise hand, which will make the interaction more interactive. Those who are interested also in meeting us, they can post in a comment in a chat box. stating what would be their contact details. So then we'll come one-on-one basis and we'll meet them. Yeah. So I'll just invite Rajat sir for succession and
Inheritance.
inheritance talk. 1 minute, sir. I'll just share the host rights. Yes, sir. On to you, Rajat sir.
Good evening, ladies and gentlemen. Thank you, Himani, and thank you, Ashish Bhai, for giving us an opportunity. I think this presentation, now that you have shown the key ways of how to make money, even in very stretched situations of how the year end is ending and how else, I think, I mean, your clients would be wanting to also take care of how to transfer this wealth in future years. So they will be in the next 14 days investing and making good yields, and then they also need to look at how it goes further. So with your permission and thanks to Wealth First Pune, I'm taking you to details on how to handle inheritance. So let me start with the first slide on you are born in a family. You are born to your parents, Mr. and Mrs. You have born to your brothers and sisters on your birth, and that's why you get a family name or a surname. This is known to everybody because that's where we come in. However, because of this birth, it creates eligibility for inheritance. And as you know, death triggers inheritance. So you have a birth which creates the eligibility and your death which triggers inheritance. But there are two exceptions to this. One of the exception is that when a child is adopted under Indian Adoption Act, then the legal structure paves the way for the child who is not born to their parents, but paves the way for inheritance. Similarly, post-marriage in India, the women get woven into the social fabric of a family arising out of the wedlock, and hence they get into the web of inheritance eligibility. As you all know, no one is immortal. Well, life is uncertain, death is surely certain, and no, nothing should be left to chance. You cannot have yes, no, and maybe, because you all know that death is imminent. Today, tomorrow, day after, someday, sometime, it's going to strike you. So why don't you look at this slide, wherein age is not a factor at all. You had the best of gymmers, the people who were too agile or wanting to know about their health, they probably died. We have Raju Srivastava, we have KK, we have Shane Warne, and of course, we had the Karnataka actor. So can you identify yourself in this part of the family? When I'm saying this to my viewers today, please identify your part of this family. You have the baby boomers who were born in 1945. So with due respect to the seniors in this meet, they were the baby boomer generation, as they call it. Now, if you look at this, they had not inherited any assets from their parents. Also, they worked very hard to build up their own wealth. They saved every penny that they had. They gave the best of education not only to their children, which is we as Generation X, but also they took care of their siblings, because in those days it was not nuclear families. And then they had a small house in the village or maybe in their own native. But before retirement, they looked at a small house in the city that they settled, not with the idea of investment, but with the idea of having a ceiling after their retirement or post when they stop earning money. That was their whole objective in life. And if you recollect, in all the vacations, that is a summer vacation and maybe Christmas vacation, they used to take you to their native place, maybe the parental or the maternal. Now look at what has happened to Generation X, which is if you are born in 1960 to 1970s, I am one of them. So we are in this category. Well, whatever we have earned in terms of our knowledge is thanks to our parents who really did well to educate us. We are not expecting anything from inheritance from them, but few of us were lucky enough and we had all the options available, or I could say all the tools available to make money, from ESOPs to stock market to real estate to ETF to commodity exchanges to bonds and so on and so forth. And with all this financial jargon that I just mentioned, your wealth got enhanced. And I'm sure people like Wealth First were eligible, available to you to enhance the wealth. Now, what did we do? We gave the best of education to our children. We had not only one house, we looked at a weekend house, maybe one house for rental income. So we started treating real estate as an asset class. And then what we did, we went on vacations, not only to India, but to exotic places abroad. So we brought the quality of life up for our children, gave them very good education. In fact, some of us, if we could afford, we send our children abroad, even at undergrad level. And that's what we did. And look at our children, Generation Y, 1980s to late 1990s. They are basically got the best of education. They have accessibility to high information and exposure to disposable income. They are driven by consumption and not by savings. And what they look, they are not interested in their parents' wealth. Now you are in a fix. If you are born between 1960 to 1970s, if you don't take care of your parents or parents-in-law's wealth by making them inheritance compliant, when they kick the bucket or when they die today, tomorrow, day after someday, you will have to do the running about whether they make a will or not, or whether they go follow succession. And you'll have to run away not only for yourself, maybe for your siblings whom they want to leave behind, but it is you who have to be running about. When I say you, I necessarily do not mean you as a beneficiary. I mean you as one of the siblings also who could be the beneficiary. And look at your side, when you make all the wealth, if you don't plan your inheritance or do not make proper preparation for the uneventful date, then your children are not going to waste their time and to see and recoup the wealth. So it is for you, and the onus of the entire family is now on you. So how do assets move through legacy? On demise of an asset owner, there can be only two ways. Either through a testimony document, which is either a will or a trust deed, or through, if there is no testimony document, then you follow the laws of the religion of the deceased person on birth. So if you are a Hindu, Jain, Buddhist, or a Sikh, you follow Hindu Succession Act. If you are a Parsi, Christian, Jew, or anyone under Special Marriage Act, you follow Indian Succession Act. And if you are a Muslim, then you follow Muslim personal laws. I'm not going into the detail of each law because that will take a lot of time and a lot of bandwidth. It's already late in the evening, and I'm sure I'm taking a lot of your time. So we have come across situations when the bereaved family of a deceased face multiple situations where they demise. Post demise, first of all, the family sees a huge void. More so if he's the breadwinner or she's the breadwinner. There is a priority is to bridge the cash flow which you require for sustaining. Transmission, that is transfer of assets from the deceased to that of the family or the beneficiary, is a process-driven, time-consuming, and legally embedded process. Stringent laws are established procedures already there, so you do not have any space for any interpretation. And what we really find is, in reality, in most of the cases, the surviving spouse or the family is unaware of where the assets are or where the wealth of the deceased is. If they are aware, they are unaware of finding the documents which are giving the right of the ownership of the deceased. If they have both, then they do not know how to handle the property or the assets because they don't know how to transfer or transmission it. To all this, then the contracts or the documents may not be in a state that it can migrate to the next beneficiary. So in some cases, we have found that lack of knowledge makes a tiff between siblings and between parents. So there could be family disputes uncalled for which arises. So what are we about? We are saying we are inheritance-related services provider. We have two services, one as a proactive approach when you are alive. I suppose at the end of this presentation, you should be in a position to take a decision and get back to Himani, my counter colleague there from Pune, to tell you of the service of preparedness for inheritance compliance. It is very simple. We plan for our vacation, we plan for our marriage anniversary, for our child's birthday party, but we do not plan for a death which is sure and certain because we don't know when it's going to come. So we better get planned. So this is a proactive approach, and the name of the service is preparedness for inheritance compliance. The other one is that you have not planned and the event actually happens, and then you need a service to do all the running about, and that's why it's a reactive approach, and it is known as inheritance needs. I will take you to both of these services together. So this is the first service. It's a proactive decision. We take details of all your assets in terms of documentation. note it down. We run a simulation in which we presuppose your demise with that of your spouse, and then we put all the assets into a category known as the asset category, which is the risk category, such that if you are a joint holder with your wife or spouse, and if you have or you are a sole owner with your spouse as nominee, naturally that particular asset, if we presuppose that both of you are going to die, is going to land up into a high risk category, because the asset becomes an orphan because both have died. Similarly, basis the document diligence, we are in a position post simulation to put every asset in a particular risk category. After that, we do the risk grading and have a talk with your chartered accountant or your wealth manager, who knows you much more than we know you. And then we arrive at a prescription on how to de-risk you at the time when you are alive. Because whatever documents that you make is cheaper, faster, smoother, and cleaner when you do it when you're alive. And that's precisely what we do. So on the prescription that we receive from your advisors, a legal advisor, maybe a family advisor, or maybe your wealth manager or your chartered accountant, we redraft all the documents and realign it to bring it to a low risk category. This entire service, if you see, starts from making a acceptance of a proposal, signing of a non-disclosure agreement, doing the diagnosis to arrive at the status report, getting the prescription, doing all the documents that we are required, and then finally we bring it down to making the final simulation and also the will. Now, will, after we give you the draft will, we have the deliberation amongst yourselves and try to include whatever you are in a legal manner, and then give you the final will. The second service is post-demise, when the concerned person has died and the family is grouping behind to find how to retrieve the assets. In such a scenario, we become the CEO of the situation, and if there is a will, we will serve the executor of the will, and if there is no will, then we do all the running about to be able to arrive at the succession certificate to be able to see that the assets transfer from here to the other. Similar in this, there is a proposal, then there is an acceptance, there is a signing of non-disclosure agreement, and then we take it further. So what I want to tell you is that in both this, the pricing is a fixed fee pricing. It has nothing to do with the value of the assets. So there are typical questions which come across: at what age should I make a will? Or at what net worth should I make a will? And some also ask me that I have assets in joint names, or additionally I have nominations, then why should I make a will? To answer this question, I think it is very, very clear that I should tell you that nominations in a bank account do not have the rights of a legal heir. Nomination in a life insurance policy is only a trustee. Nomination in mutual funds is only a custodian. Nomination is a demat account only becomes owner for an interim period. And nomination in a housing society or a condominium is only a custodian. So what we are saying is, in all this, the nominee is only a safekeeper. He is a godown keeper. He is not purely the owner. That's why he cannot sell these securities or these assets and take the money and run away. Did you know that if you have fixed deposits, and I'm sure most of you have, and in a joint with your spouse and under an either or survivor clause, if one of you die, then though it is either or survivor, you cannot prematurely withdraw that particular FD, because as per the stipulations of Reserve Bank of India, you should undertake a document which says and intimate it to the bankers that even if you die one or the other, then you should be able to premature. This has appeared in my article in Money Control. You can Google it and find it. And after this article which came up, I'm happy to state that two banks have changed their forms. One is Axis Bank and one is Union Bank of India. I want to take you through this immovable property because this is the most discussed topic, and about 40% plus of anybody's wealth comprises of real estate. As I mentioned to you, land could be on agriculture, non-agriculture, it could be residential or commercial, it could be on an independent house on a land, it could be apartment in a cooperative or society or condominium, it could be on collector's land, and of course in some places like Pune, it could be under the Cantonment Act. Take you further, the schematic activity, how it is used to plan earlier, was a builder buying it from a builder, then you had A to selling to B, B sells to C, and when Mr. and Mrs. D buy it, they take a bank loan, so there are two people. What I want to emphasize is that unlike before, this Mr. and Mrs. D started becoming a co-borrower only when the banking started. But now how is it? Suppose you buy a property from a builder A, I'm talking to the referring to the diagram below, and then A sells it to B and C, and then in B dies, then the portion of B, beneficiary of B, if Mrs. B dies, then Mr. B should be transferred either through a probated will or through a succession. Only then you register the new owners and then register a deed of transfer, pay the stamp duty, and get an index too. People are not aware of this mutation clause, and they think that because me and my wife is to own it, and if my wife dies, the property belongs to me by default. That does not happen unless you have either a probated will or through a succession act. So why is this noise all about? It is about because will is the only document which has been the bearing on the will distribution of the testator post demise. Any mistake in his drafting, recording, ownership poses a serious challenge to the executor, and the bereaved family would need to make more efforts in reviewing its own wealth entitlement, and efforts could be time consuming and cost gulping. Some of the people here could have NRI parents or could have NRI children. This is slide dedicated to them. When your children left this country and went away, they had some assets. They did not look at that assets. For a few years, it was lying. It got matured, got reinvested. Today, now, they have not declared this asset in their respective country of domicile. And if they don't make the proper documentation, they cannot take it from here to there in any case. But they have to make preparation such that when they die, the next generation who is not going to come to India to recover this money can get it. So inheritance for them is more critical. The second leg talks of people who are in NRIs and your siblings probably, you have your siblings and you have parents in India. They want to leave behind something for your brother or your sibling who is abroad. If they are not prepared, then he will have to come or she will have to come to unlock that value for your. So revisiting is cost expensive and time consuming. How have we positioned the company? We are a risk assessor. We ensure that assets moves further. We have a field force on the field for 83 cities. We are beyond will writing company, and we are non-advisory. So there is no conflict of interest between me and WealthFirst or any other wealth advisor, because I don't advise. I don't comment on any yields or returns. We do not collect any original documents. We do not take any value of the assets. We do not take any power of attorney. So there is no question of fraud in our organization while serving. Are we comparable to law firms or evil portals? Unlikely and no. The reason diligence which neither the evil portals nor the law firms do. Before we even start, we carry on the simulation to arrive at a relative risk. And INSPL is a wellness perspective, and it provides feet on the field. We do a rigorous due diligence to give a robust enough will which can last for minimum 3 decades. Shortcuts could be very expensive proposition. Wills in most cases are used as repository, hence information of the assets and liabilities need to be correct and precise. Will drafting is critical as the only document which is the reference point for wealth distribution. Cost of making will is least relevant, as cost of not making a will is extremely high and cumbersome. Choice of the executors is a critical decision. E-will portals seek silent to personally enter information and data. E-will services through portals are enabled on standardized will formats. They do not factor in situations or stability of craft of wills. In case you don't die and you turn into a patient, Alzheimer patient, or with acute arthritis. Is registration of will needed? Well, will is a supreme document and will override all nominations. But let me tell you, the registering of will is not compulsory, but many prefer registering their will. More so, testators who feel that their assets or wealth are diverse and the distribution could hurt a few of the beneficiaries. For them, I think registration is 100% compulsion rather than option. Also, as per the Act, a registration will can be registered even after death, but in practicality, that's a little challenge. A will made before demise of a testator but not registered after the registered will would be valid if no suspicious circumstances. So the last will is the valid will. Well, people often ask us why register will. Well, you know that immovable assets in Bombay, Kolkata, and Chennai require a probate. Hence, if the will is registered, the transaction is much more smooth and it is easy for the legacy. A probate does not in any manner comment on the contents of will. It is only a process of certifying the will. People normally ask me that daughters have an equal birthright to inherit property. Yes, they have an equal right to benefit property, but that's only if the parent or the father has not left behind a will. So if the father has left behind a will, the will is the supreme authority. So what we feel is inheritance is a social responsibility. One needs to address it. The address the issues of inheritance while you are alive. It will ensure protection and earnings of wealth to the next generation, and seamless transition to legacy is very critical. This reminds me of a movie known as Guzarish. You must have seen it or heard about it. It is the first film in India which laid the foundation of a living will. Living will, Honorable High Court in 9th March 2018 put it as a medical advisory, which means if you are in a position of palliative care or not able to take a decision on your future, wherein you are either in comatose, then you can leave behind a living will so that your near and dear ones can instigate the authorities to plug off the ventilator from you and give you a peaceful death without pain whatsoever. I'm open to questions and answers. Please feel free to ask questions. The moderator, Himani, is in charge.
Thank you, Rajat sir. I'm so happy to see you all in this meeting, enthusiastic participation in this meeting, sir. The topic of the day was how one can approach investing in March and in coming months by our expert and MD of Wellfirst, Mr. Ashish Shah. And also the important subject of the day was inheritance and succession with our expert, Mr. Rajat Datta from Inheritance team. So, sir, I would request anyone of you, if you have any queries, you can raise your hand. We'll just unmute it, and we will we'll open up a session for Q&A from by Ashish sir and Rajat sir. Yes, Sumedha ma'am. 1 minute. I'll just unmute you. You can press a unmute button. Yes, Sumedha ma'am, you can press unmute button.
This question is for Mr. Rajat Shah. The presentation was wonderful and precise. I have a question. What is exactly known as a family trust when we want to transfer our inheritance to a single progeny?
So let me take you through this slide, which will give you the whole idea of it. So you need a document to transfer it to the next legacy. And to transfer it to the next legacy, you can do it only through a document, which is a will or a trust. Now, the most simple way of doing it is through a will, but some prefer to go to the trust road. There are reasons behind it, if they are typical to the requirements of that particular family. As far as we are concerned, we can only tell you a trust is required if you have one of the following points. The first and foremost, you have an asset, you own an asset which is not divisible. Typically, you have a house of maybe 4.5 bedrooms and you have 5 children, or you have 2 children, and that's going to be a problem. And you think that the who's getting deprived is going to file a case or suit against you. Third, if you are not
Your voice is not breaking, it's cracking. Hello?
That you require to give. Okay, can you hear me now, sir? Yeah.
No,
Can
Rajat,
you hear me
I
now,
think-
sir?
Excuse, last 2 statements, please repeat. That's why it was not audible properly. I think
Surely.
it is cracking, it's cracking.
Video feedback.
So, sir, can you hear?
I think you
Can you
switch
hear
off.
me now?
Now,
No,
yeah.
still, yeah.
No, not much.
Yeah. So So the answer is that if you have assets which are not divisible and you think that it will be undivisible, like you have a 4-bedroom house and you have 3 children, then it is better to give it to a trust. If you think that you're going to give money to the children who are not able to handle all the money together and you need to give them in bits and parts spread over the next 10 to 15 years, then you should take the use of a trust. If you have a special child, yes, you need a trust undoubtedly. Second and most important part, last and the most important part, that if you have any asset such that which is disputable by the other, then you should form a trust.
So your
So
voice is not heard.
Can you hear me now? Am I audible?
Yes.
Yeah. So I think there is a touch point of 4 or 5 issues. If you fall in that touch point, then I think you need a trust. But I would suggest we can have an offline discussion as well. Himani madam, if you can just organize an offline call, then it sort of, in the interest of time, we can just explain it in more detail.
Thank you, sir. Thank you.
Himani, I have a question.
Yes, sir.
So, this question came to my mind when you, I think in your first 1 or 2 slides, where you talked about some exceptions to, that slide went off fast, but some exceptions regarding adopted children.
Yeah, Rajat sir. Hello.
Yeah.
Adopted. Yeah. So it is. Yeah.
So I have an adopted child. She's my only child. And, I have a document from the High Court which says very clearly that this certificate issued by the High Court is equivalent and eligible for all laws of this country, for all purposes.
That is precisely the fact that I mentioned, that the exception is that in case of adoption, the legal structure gives way to your daughter or son to become inheritance.
So it's not an exception then. It's
exception is because by birth only you get eligibility for inheritance. But the exception is that your daughter is not born to you.
So adoption through the High Court is equivalent to birth.
Yes, so that's what I said. That only if you are born you get eligibility, but if you have been adopted, then the legal structure gives the way.
So it's the same thing as being born.
That's right. That's right. So similarly, you
Because,
marry a girl.
This is giving an exception to the top 2.
No. So the word is that a birth creates eligibility, but the exception is if you are adopted, the legal pay gives the way. And if you are married, post-marriage, women becomes get into adoption.
All right, cut this topic. Let's move on.
Surely.
So I would request, if anyone has any queries, any doubts, please feel free to ask.
Can I talk once more?
Yeah.
Yeah,
Yeah, this is for Mr. Ashish Shah. I wanted to know a little bit about the HDFC Sanchay funds.
See, we use this as a permanent cash flows for the individuals. That is the idea. As I say, insurance, we don't like for investment, but this is a long-term investment assured. That's why we are using insurance vehicle. There are a couple of variants, but simple variance is like this. Suppose I pay 10 lakhs rupees for 10 years. And after 12th year, I'll get some around 12 lakhs rupees, some exact amount like 1180 or 12 lakhs rupees as per the age. For another 30 years, assured is irrespective of interest rate. And after that, I will get 103% of my paid premium, that is 1 crore 3 lakhs rupees back me. Now let me tell you in short, these 30 plus last cash flow, 31 cash flows will be used by insurer, like suppose it is myself or my wife or my son or daughter. Somebody will use this 31 cash flows. In short, I pay 10 times. HDFC gives me 31 checks. We do not know who is going to use it as per his life. Like after my demise, that cash flow will be used by my wife. And after her demise, my son will get that cash flow and the principal back. And it is around 7% tax-free return. In short, this is the idea. Suppose you are a little bit higher age, you can go for 5 payment, and from 7th year, you start getting money for 30 years. There are a couple of variants. I think Imani can help you one-on-one or any point of time. But this is one of the best deal ever come across in my life.
Thank you, sir.
Even I think you should explain her in a very detail, because there are so many variants. You can use the age per the age and the children and all.
Yes, sir. Definitely, I'll do that. So any more questions, queries?
I think you share one or two examples of inheritance, then some of the people will get idea for questions.
Okay, so let me take you through a few examples. I think Ashish has triggered a spark.
Yeah.
So let me tell you of a person who had a husband and wife, and he made a will. And in the will, he said that after me, my assets should go to my immovable should go to my 2 sons, and my movables should go to my 4 children equally. He had a house and a flat, and he made a will in Marathi, and after that he died. So what typically happened is that when they opened the will and they saw that the will was written in Marathi, they went up and filed for a probate, because he had a house in Bombay. And they found that the witness, this one witness had written the signature, and the other witness had written a name. So the judge asked in the petition that the other witness, there is no signature. He said, no, he has died, but that was his signature. His name was his signature, like many people write, right? And when they went up, the judge gave a call that the family needs to be called, and wherever he had bank accounts, they need to be issued a notice that we want copies of his signature. And they found out that that was his name and not his signature, because actually he had not signed. They later on made that signature and gave it. Now, in such a scenario, just threw the probate petition out. So that means he was treated as he died intestate. So his assets now got converted, the house between 5 people, that is his wife and his 4 children. So everybody got 1/5, 1/5, and 1/5. His wife said, no, I'm not going to make a ass of myself. Let me make a proper will. So she said, from my assets should go house equally to my both sons, and the other movable should go to my 4 children equally. And she died for the probate, and the probate was admitted, and they said that now you own only 1/5 of your husband died. So only 1/5 will go among 2 children, and the rest will go equally. So now you can imagine the trauma. The gentleman had made a will, but he did not know how to write a will. And his wife was more smarter. She did not still know about how to write the will. And they saved the money on the lawyer. And what typically happened is that every child had a particular stake in every asset. And it's in a mess, because they will now not speak to each other. And when there are girls, they get married. There are brother-in-laws coming in. And when there are boys, they get married, and there are daughters-in-law coming in. So that's the mess of making a will. One person said that after me, my wife, and after my wife, my son, and he died. And after his death, the wife took all the property. And in the interim, there was an epidemic, and the son died. So the wife of the son said that now my husband has died. So after you, please give the money to me, because I have no other source. And the mother said, sorry, I cannot follow the will, because the will was a conditional will. Now it is my property. I want to give it to my other daughter, who is financially very deprived, rather than give to my daughter-in-law, and so forth. So that again failed. You have a third case scenario in which, Uttarakhand floods and everybody was washed away. And so the government normally used to wait, as per the law, used to wait 7 years till you get everything. And the 7 years, because everybody is washed away. There was a special directive for Uttarakhand floods, Kedarnath floods, if you remember, 2009, 10, in which they said that after 2 years, if your person is not found, then you declare dead and the death certificate is issued. So they issued the death certificate, and on the basis of that, they got in touch and they distributed the will and all the assets. This gentleman came back after 5 years, and he found all his assets were distributed among his beneficiaries. So he had no choice. He appeared before the court, and the High Court granted that whoever has been beneficiaries, in the ratio of the asset that they have got, they need to take care of this gentleman for the lifetime. So these are issues which are real life issues, and so on and so forth. So these are some of the cases which really keep your mind thinking.
$1 million euro.
I think
Yeah.
things are we have to be very clear. See, throughout the life, we do hard work for earning money and paying tax. And whatever we save, it should go to our whatever trust or whatever charity or our children or anybody in a very peaceful and systematic manner without jagde. I think that is the idea of this inheritance. And we have seen, because of we all people are making reasonable wealth now. So these all problems are also increasing in the country. If you go to any civil court, I think 80% of the issues are of the land and the power of attorney and the inheritance. So let us make the things in order while we are alive. That is the purpose of this inheritance. And our we know why, all gentlemen and ladies, I want to say that our job has been to 30 years, we create wealth for our clients. Our client does hard work, they save money, they spend little for children and all. Now after that, it should go to the next generation also in a regular manner. Now a lot of a single child is there, people are staying abroad. I think this whole process is very important, and we all are not doing that, is my experience. And that was the idea of bringing Rajat on the show. That's why we do not have any problem. It is like our passion to take care of our clients. That's why you can ask any question, otherwise we can close after that.
So, sir, I would like to express my sincere gratitude to each and every one of you for attending our session today. I hope it has been informative and insightful, and that you have gained new knowledge and perspective from our esteemed speakers. We are fortunate to have such knowledgeable and experienced professionals to share their expertise with us. Once again, thank you all for your participation and making this seminar a memorable experience. We hope that you will continue to engage with us in future. Thank you. Thank all. I would like to thank all of you from Team Well-First and
Thank you very much. Thank you.
Thank you, Himani. Thank you all.
Thank you. Bye.
Good night.
Thank you, sir.
Right.
Thank you, sir.
Thank you.